Thank you. And so next, I'm really pleased to introduce Associate Professor Linda Steele. Linda is a respected socio-legal researcher from the University of Technology, Sydney, with extensive expertise in the intersections of disability, law, and social justice. Her work has been crucial in advancing our understanding of how restrictive practices are framed and experienced, and how we can work towards eliminating them in ways that uphold human rights. Today, Linda will share insights from the Evidence to Action brief she co-authored, highlighting key research gaps and opportunities that can guide us in eliminating restrictive practices. Please join me in welcoming Professor Linda Steele.
Thanks, Jane. And thank you to everyone who's here today for coming along for this important conversation. I'd just like to begin by acknowledging that I'm on the lands of the Gadigal people of the Eora Nation, and I'd like to pay respect to elders past and present, and also welcome any Aboriginal and Torres Strait Islander people who are here today, and recognise that First Nation sovereignty over this land has never been ceded. By brief introduction, my pronouns are she, her. I am a white woman, aged in my 40s with greying brown hair. I'm wearing a red and white dress, and I'm presenting from my office, which has a white wall behind me. Thank you to Mary Sayers, CEO of the NDRP, for her invitation to speak today, and also to Sue Tape for her guidance in preparing this presentation. Thank you to Poppy for sharing her experiences. And before I get into my presentation, I just wanted to say how exciting it is and how grateful I feel to be that we are at this place in the discussions around restrictive practices. For so long, so much energy has been put into establishing that restrictive practices are wrong, are harmful, are violent, do violate human rights. And to actually be at this place when we're starting from that as our beginning and looking at how we go about elimination, what research we need, what evidence we need is really in itself significant and something I think we need to recognise as successful in itself. So the research foundations for this presentation are a research report that was commissioned by the Disability Royal Commission on eliminating restrictive practices. I'd like to recognise the leadership of and vision of the lead author of that report, Claire Suvakovsky, and myself and Dinesh Waddiwell co-authored that report with Claire. So I'd also like to acknowledge Dinesh, who unfortunately could not be here today, and who is the co-author with me of the Evidence to Action brief at NDRP. And I'd also like to really thank everyone who engaged with us during the Disability Royal Commission research report, particularly the disabled people's organisations and others in the disability advocacy community, and those that were on our expert advisory reference group, including some who are here today. And most importantly, before I begin, I'd just like to recognise the lives and experiences at the centre of the topic that we're talking about today. People with disability who are subjected to restrictive practices. And I really encourage you to have a look at the Disability Royal Commission research report that I'll be referring to today. That includes an entire chapter of people's experiences of restrictive practices as told by them, and obviously also the Disability Royal Commission's reports as well, that documents so many people's experiences. So today I'll be briefly discussing what restrictive practices are, human rights issues, the harm and lifelong impacts of these practices, and the cultural and systemic impact. Slide, please. Okay, so what are restrictive practices? Well, Jane gave a little bit of an overview of that already, but myself, when I say we, I'm referring to Dinesh and Claire with our research report. In our report, we defined restrictive practices as practices that are at odds with the human rights of people with disability and represent a significant form of violence and coercion. And we devised this definition that's up on the slide based on the findings presented in our research report. So we say that restrictive practices are legally authorised and or socially and professionally sanctioned violence that targets people with disability on a discriminatory basis and are at odds with the human rights of people with disability. Restrictive practices include, but are not limited to, chemical, mechanical, physical, and environmental restraint, seclusion, guardianship, forced sterilisation, menstrual suppression, and anti-libidinal medication, financial management, involuntary mental health treatment, and other non-consensual or coercive interventions, whether they are said to be undertaken for protective reasons, behavioural reasons, or medical reasons. So this definition emphasises three aspects. Often, restrictive practices are authorised by law and sanctioned by the community and by professionals. So this then means that restrictive practices are set apart from other forms of violence, which are typically seen as crimes or criminal offences. They're illegal. Restrictive practices are discriminatory in that they apply only to people with disability. Similar interventions on non-disabled people are given other names and are subject to more legal oversight. Even if, and I know that Professor McEwen mentioned this before in his presentation, the very concept restrictive practices is a specialised technical term that is not well known to the broader public. And indeed, sometimes people with disability who have been subject to restrictive practices don't always themselves have not been taught or had their awareness raised about what restrictive practices are as well. So it's a term that is so specialised that sometimes that terminology itself sits it apart from what we understand to be violence or human rights violations. And the third aspect of our definition is that restrictive practices violate human rights. So there's a wide range of examples of what restrictive practices might be, and they're used in everyday settings, such as homes, schools, and healthcare environments. And our definition of restrictive practices is not too different to the definition utilised at the time of writing our report by the National Disability Insurance Scheme in its rules on restrictive practices as well. Next slide, please. So as we talked about in our research report, use of restrictive practices is at odds with international human rights obligations for the treatment of people with disability. There is an absolute prohibition in human rights on torture and cruel, inhuman, or degrading treatment or punishment. So this means that restrictive practices that rise to the level of torture or cruel, inhuman, or degrading treatment or punishment, they must be prohibited. They can't simply be regulated by law or subject to complex processes of approval and oversight. They simply cannot be allowed at all. And this is in the Convention Against Torture. And also we see this in the CRPD, or the Convention on the Rights of Persons with Disabilities. Additionally, there are strong human rights obligations in the CRPD relating to prohibition of discrimination against people with disability, and also rights to protection from violence. There are also human rights obligations about people with disability having autonomy over their bodies and support to make decisions about their bodies and lives. And we also have human rights obligations in there about freedom of liberty, so people can't be detained. The principle of dignity is at the core of international human rights obligations to prevent torture and ill treatment, and also is at the core of obligations related to protection from violence and equality and discrimination. And use of restrictive practice fails to respect the inherent dignity of people with disability. And this is insofar as restrictive practices represent a form of violence that is applied on a discriminatory basis to people with disability. When this is the case, these practices, even if they don't rise to the level of torture, are still at odds with international human rights law because they reflect discriminatory treatment. So by reason of the human rights situation of restrictive practices, research and policy must be guided by a commitment to upholding human rights, focused on how to eliminate restrictive practices rather than thinking about how we can justify them, regulate them, or manage them, or even simply reduce them. Next slide, please. So our analysis of the lived experiences available in advocacy submissions, government reports, and academic research documents the harm and trauma caused by restrictive practices. And this is both physical harm, but also psychological and social harms as well. And these effects can be lifelong. And I'll just briefly introduce some of these. So firstly, trauma, pain, harm, and violation. So our report includes numerous accounts of people with disabilities speaking about their experiences as physically painful, psychologically harmful, and as a violation. Secondly, abandonment and neglect. So our report provides numerous examples of people with disability who were either left alone in seclusion without any supervision or had their experiences of distress and harm ignored. And this resulting effect of these experiences was that people with disability felt abandoned by those who were tasked with supporting them, and in turn they felt helpless to improve their circumstances. Thirdly, fear. So based on the accounts that we examined in our report, many people who are subject to seclusion describe their experience of this as frightening. And this manifests in different ways. It could be not knowing what will happen next, or it could be the brutality of that experience. Fourth, we found disempowerment, humiliation, and dehumanization. So our report provides several examples of people with disability speaking directly about feelings of powerlessness in the context of restrictive practices. So feeling like they had lost total control and everything had been taken away from them. Fifth, cruel and punishing treatment. So there were examples of people with disability describing being subjected to restrictive practices who experience this as cruel or as a form of punishment. So this includes people who talked about being put in cages or subject to experiences that made them feel like they were caged or treated like an animal. Several accounts provided in our report expressed a common rationalisation among some people with disability that, oh, they must have done something wrong to have been punished in this way. So that feeling that of shame and confusion about why this was even happening to them. Also, lifelong trauma and life-altering effects. So based on the accounts in our report, some people with disability felt that restrictive practices had life-altering effects and contributed to lifelong trauma. And it kind of fundamentally changed how a person with disability understood themselves and were able to understand the possible future they might have. Next slide, please. So restrictive practices take shape in an ecological system of violence, coercion, and control. And this system extends from individual people with disability out to kind of concentric circles of relationships, institutions, and society. Ableist attitudes, a lack of resources, and systemic issues in sectors like healthcare, education, disability, and aged care perpetuate the use of restrictive practices. Going off, kind of building on what Alistair, Professor McEwen mentioned earlier, use of restrictive practices is often normalised or justified in response to what is referred to as behaviours of concern. So we kind of justify it as being the fault of the person and their bad behaviour, rather than addressing the root causes and unmet needs related to this behaviour, which is a legitimate response to harmful environments and circumstances. And this is captured by the image on the screen. And I'll just briefly talk about, I'm nearly done, briefly talk about the different circles in this ecosystem. So firstly, the individual considerations. There are assumptions about behaviours of concern. So restrictive practices are often presented as necessary response to an individual with their perceived behaviours of concern. Our report shows that interactions commonly classified as behaviours of concern are better understood as adaptive behaviours to maladaptive environments. Secondly, relationship considerations. So additional to the misinterpretation of an individual's experience and behaviour, then there are uneven power dynamics at the relationship level. So interacting with and extending from these assumptions about behaviour, there are relationships between people with disability and those who are tasked with supporting them. So our report shows how the use of restrictive practices breaks down relationships of trust between people with disability and support people, and also further entrenches unequal power relationships. Third, institutional considerations. So relationships between people with disability and those tasked with supporting them take shape in institutional and organisational context. And the research is unequivocal. People with disability are subject to the greatest use of restrictive practices in segregated and congregated contexts where they're clustered together and there's less access to support or transparency or advocacy. Research suggests that people with disabilities' lack of choice and autonomy within these settings is a key factor that contributes to the increased use of restrictive practice. Research also suggests that both within these segregated settings and beyond, there are 5 core workplace concerns about restrictive practices that drive the use of restrictive practices. So the experience levels of staff, institutional cultures of blame and risk management, occupational health and safety concerns of staff misconceptions about their duty of care obligations, and under-resourced services and supports. Next, societal considerations. So ableist views towards people with disability position people with disability as lesser than and naturally unequal to people without disability. These views legitimate beliefs that people with disability can and should be subject to violent and coercive forms of intervention that would simply not be tolerated in relation to people without disability. Research suggests that ableist views can often be disguised in the service and support sector as benevolence, so as a commitment to care or well-intended protection for people with disability. And for some people with disability, use of restrictive practices is further shaped and rationalised by other forms of prejudice and discrimination, such as racism and sexism. And currently, there are few, if any, consequences for staff who use restrictive practices against people with disability. And this is because currently restrictive practices are permitted and regulated via law and policy. And this permission sustains cultures of silence and further enforces the unequal power relations. Ultimately, law enables use of restrictive practices by not holding those who use them to account and by denying redress to those who have been subject to them. And I'll finish up there, but I'll just put up on the screen while I'm finishing the final slide, which is our 8 steps to eliminating restrictive practices. And you will see in the evidence to action report by Dinesh and I some elaboration on where we might focus research in developing further knowledge that can drive this 8 steps to elimination. So, and importantly, you will see there that it's not simply about introducing laws, but addressing issues such as deinstitutionalisation and desegregation, and taking trauma-informed approaches to service provision, and also delivering redress and truth-telling as well to ensure we're recognising people's past experiences of harm and learning from that so we change laws and practice in the future. So thank you.